financial creditors and predators, family fighting. Oh my. Hey folks, Elder Law Care attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, great to see you here today. Folks, our YouTube subscriber sent a great question in. I love this question. Hey Patrick, what do we do when we have a blended family? How do we create, what is the best way to create our estate plan, our trust when it is a second or subsequent marriage? Folks, we refer to that as the blended family, or some of you may recall the Brady Bunch. Yes, Mike and Carol Brady. They came together as a union of marriage, and Mike and Carol came together, 3 children each from their own respective families, and they joined forces and became one. One. So, folks, pull up your chair, get your notebook out, because we're going to be answering that question today on the very most protective, most effective way you need to create your estate plan around that when you have a second marriage or subsequent marriage and you're bringing your family together, blending your family together from prior marriages or prior relationships. What's the most effective way to create your estate plan? And folks, this is typically the answer. And this is how I advise our clients. When they're coming to the table with a second or subsequent marriage, Brady Bunch situation, okay? Mike and Carol Brady coming together. Your elder law attorney needs to do the requisite counseling and say, okay, Mike and Carol Brady, how many children do you have? Mike says, well, I got 3 kids from a prior marriage. Carol says, I got the same. I have my 3 children from a prior marriage. So you have to stop doing the requisite counseling as the elder law attorney and say, well, gee, what if Mike goes first? And in this situation, say Mike and Carol Brady, say Mike is 70 and Carol is 65. And Carol appears to be in better health and younger. So in that situation, hey, Mike, if you go first and you only have one treasure chest with all your treasures in there, right? And you're taking care of Carol, right? And you want to take care of your 3 kids, how is that going to look? How is that going to work out? So there's a lot of psychology and that goes into these situations that needs to be assessed and evaluated and considered as far as putting together, designing, and drafting that very best plan for Mike and Carol Brady. In my experience, the very best way to slay not just probate court, but also the tax man, and right here, bloodline protection for all, is Mike and Carol Brady creating separate revocable trust. They need separate treasure chests, folks. So listen, please listen, because this is extremely important. So Mike ought to have his own trust with his own treasure chest. Carol also needs her own trust with her own treasure chest, okay? Mike and Carol need a design, terms and conditions in their respective trust, taking care of each other. For example, if Mike checks out first because he's the older spouse, he needs language in his trust saying, I'm taking care of my beloved Carol, my spouse, spousal protection for the remainder of her entire life. But that principle should be protected and preserved as well, because Mike wants to reserve and retain that for whom maybe his 3 children and maybe even his grandchildren. So that needs to go into Mike's trust. If Mike has a separate house, that ought to go into Mike's trust. If Mike has his own financial assets, which he likely brought into the marriage, that ought to go into Mike's trust. But Carol can touch it as the surviving beneficiary and maybe co-trustee to the trust. In the design, Mike ought to consider who would serve as his backup trustee in addition to wife Carol in the event he became disabled or incapacitated, and then also when he dies. Maybe his oldest son, to keep an eye on the treasure chest, right? Because I had a case years ago, no names, of course. The dad did a simple, basic will. The simple will didn't work. The son was named as a backup beneficiary of that simple will. There was no trust protections. There was no family bloodline protections. There was probably not a lot of counseling done. And the gentleman said, hey, second marriage, my wife, Betty, gets all. And then when she goes, my son's the backup beneficiary. Very simple plan. And that simple plan did not work. And after the husband died, Betty did what? She went back to the attorney and she made her own will. She created her own will. And who do you think Betty left everything to? Yes, her children. She disinherited her stepson. So what could they have done differently? Separate trust in this situation, right? Mike Brady has his own trust, treasure chest. Carol Brady has her own trust, treasure chest. Mike puts all his treasures into his treasure chest. Carol likewise does the same. She brings assets to the relationship and she wants to safeguard, preserve those. Maybe for Mike, if she goes first, right? Mike gets to share in her assets while he's living. But when Mike goes, her assets also go to her three children and maybe not to Mike's three children. All right. So that's the best way to do it, folks. Separate, revocable asset protection. Trust is the recommendation, strong recommendation to avoid family conflict, to avoid family strife and hurt feelings, and possibly even losing the entire estate, like that situation I shared with you a moment ago when the plan was not done properly. Folks, hopefully this educational video was helpful. Scroll down, leave a comment, a question. Be sure to click the subscribe button and the notification bell because we will continue to update you with other important elder law topics. Folks, strongly recommend go to Amazon, pick up my book right here, Patrick Kelleher, How to Slay the Four-Headed Monster on Amazon. And also my second book will be released soon, which is the top 20 elder law questions. You'll see that on Amazon soon as well. Folks, thanks for joining us today at elderlawcare.com.